Hello, everyone, and welcome to another episode of the Friendly Troll podcast, hosted by the Center for Intellectual Property and Information Technology, easily referred to as CIPIT, at Strathmore University. My name is Florence Okonjo, a researcher at CIPIT, and I will be your host for this episode. In this episode, we will be specifically focusing on image rights. To help us further discuss image rights and contextualize image rights, and looking at it in terms of emerging trends, with respect to the digital era and social media, we have an amazing guest who is an expert in all things image rights, Dr. Nomalanga Mashinini. So, Dr. Nomalanga, welcome to the Friendly Troll podcast.
Thank you so much for having me. I'm honored to be invited by you, Florence, and CIPIT to come and talk about this very important topic today.
All right, so with that, I will just get right into it. But before that, allow me to give a brief introductory to who Dr. Nomalanga is. So Dr. Nomalanga Mashinini is a senior lecturer in cyber law at the University of Witwatersrand, Johannesburg, South Africa. Her research focus is on the protection of image rights. She explores the interplay and dynamics between social media and artificial intelligence and their influence on the exploitation of individual identities. Nomalanga hosts the podcast Image Rights by N. Mashinini. You'll find the link in the show notes. This creative platform extends her research dissemination strategy and has garnered international acclaim with listeners in 39 territories and 186 cities worldwide. In 2023, which was this year, she received the Female Academic Leaders Fellowship Grant, affirming the significance of her research and podcast as part of her ongoing image rights community engagement project. So as you can see, she is well-versed in all things image rights. And with that, so let's get right into it. So image rights. Dr. Nomalanga, would you please help us sort of contextualize what image rights are? Because there's some people who are already familiar with what image rights are, and some who maybe have heard of it, but not necessarily think it is associated to them in any way, or just basically don't know how that may apply.
Indeed, the term image rights is seemingly emerging. Well, it's not a new term, but it's emerging in terms of the digital age, placing a lot more emphasis on people's identities and the use of identity for commercial purposes. I mean, if we think about the makeup of a person, you are made up of yourself, your personality, your likeness, your name, signature, voice, your images. And so image rights seek to protect the public and commercial use of these elements or features of your personality to protect you from falsification of your identity, misrepresentation about your identity, or commercial exploitation about your identity. However, the term image rights, although it's universally used to refer to the same protection that I've described now, we do see certain jurisdictions refer to what we term image rights as, for example, in South Africa, the right to identity under our common law, or in some states that regulate this in the United States of America, it's known as publicity rights.
Thank you so much for that sort of contextualized explanation of what image rights are. So earlier this year, we also hosted our webinar discussing image rights and trying to understand image rights. And in that specific webinar, we also highlighted specific legal and ethical aspects of image rights, which linked to privacy and context in different ways. So in discussing this, could you also further explain to the listeners how the ethical implications of image rights come up and how they ultimately link to privacy and consent?
So image rights is mostly in most common law jurisdictions is sort of embedded or encompassed within the protection of the right to privacy. I can give 3 different examples. I'll start with South Africa. In South Africa, although we do have the right to identity, which is basically our image rights, sitting separate and independent from the right to privacy, the interests that these 2 rights are seeking to protect are quite similar. And so the where they really differ is that with the right to privacy, what we normally look for is whether there's a legitimate expectation of privacy that has been violated without any grounds of justification, like freedom of expression or jest and stuff like that, ever justifying the limitation of such rights. Whereas with the right to identity, we look to the question of, is there commercial use or exploitation? Is there falsification? And so often you see, for example, in Basitana Khumalo's case, against CycleLab, you will see situations like that where both the right to privacy and the right to identity fall into the same claim. They form the basis of the same claim. But there are instances where they separate completely. We see this in instances now, especially with social media and all of that, but I'm sure we'll talk about that a bit later. The second example I wanted to give to show the relationship between privacy and image rights is, if you think about English courts, whenever they've heard matters relating to what looks like an image rights lawsuit, they always emphasize that our English law does not have image rights protection, and that the right to private life and the family, if it's called that way, that particular right will protect these particular interests. So we saw this in the Fenty judgment with Rihanna, for instance, where her face was used on a T-shirt sold by Topshop without her permission, but with the permission of the photographer. Obviously, in a case like that, the photographer has copyright over the photograph, but very much so, the celebrity, Rihanna in this case, has certain personality rights over her own image, although she didn't pursue personality rights. She went for a passing of claim under where she claimed for the misuse or she claimed for the fact that Topshop was piggyback riding off of her goodwill, because obviously as a celebrity, she's already built up that kind of goodwill. So we see how in English courts, they'll normally, when they see a case like that, even though a person is not even claiming on the basis of image rights, they'll immediately fall back to the fact that it's either you're going for passing off or privacy interests. Same thing with the United States of America. There's been a historical debate about whether they separate the right to publicity from privacy. And what we see even in leading states in this era, like California and New York, is that even in their New York civil rights laws and in the California code, what you find always is that the right of publicity is really embedded within the privacy protection. Because at the end of the day, they still cover issues like falsification, so casting someone in a false light, issues around commercial use of someone's identity without their permission. We still see those kinds of cases where mainly in those jurisdictions, celebrities will succeed more easily than ordinary persons. If you ask me about how the ethical considerations play out, is that I'll tell you the negative part of things, that as a result of the separation of how to protect celebrities, how to protect ordinary persons, who can go for privacy, who can go for image rights, what we often see is a differentiation of outcomes. For example, there is a situation that once happened about over 10 years ago, involving a young 12-year-old girl where her picture was taken without her permission while she was wearing a bikini. And what we saw in that particular judgment is that she obviously got an award that was quite small, given the type of remedy that she had pursued. But if you compare it to the case that I mentioned earlier with Basitana Khumalo, who's a South African star, a well-known star, in that case, the court ordered that she could go and negotiate the settlement, basically, of how much this company would pay her. So there's a bit of room to wiggle or negotiate when it comes to a celebrity in that context. versus the ordinary person who has to accept what the court has ordered unless they're given leave to appeal. So there's a lot of things that come out where you see also a pattern of typically the claimants or the plaintiffs in cases relating to image rights are women. All the way from prior to the constitutional era in South Africa up until today, we see a pattern of women being at the center of this. So there's quite a lot that is happening in terms of the privacy and image rights protection, and questions are starting to come up about whether this kind of protection is sufficient in the digital era. I hope I've responded well to your question.
Yes, you have really contextualized that as well in terms of how it has evolved, how image rights has evolved over time, and we are seeing certain similarities with respect to how image rights is now being perceived. It's no longer just about those who are celebrities or those who are famous, and it's moving away from sort of a commercialized or a business sort of perspective of looking at image rights, and it's evolving to just the ordinary person. And I think this has been primarily changed because of social media has played a really big role in terms of changing how people view their image rights. Image rights is also not a new concept, and as much as certain people are looking at it in terms of it being a new concept, it has existed from as early as 1890, when we had one of the first aspects of image rights come out, where there was a painting. It was sort of a painting of a lady who was on her deathbed that came out, and that's where the elements of it started off. However, that element also notably started off with it being the fact that this person was a celebrity, and the fact that her image was portrayed there in a light that wasn't necessarily what her family or herself would have wanted at the time. So it has significantly evolved from then, and social media and technology has generally played a big role in sort of ensuring that it's not only celebrities who are looked at in terms of considering image rights or in terms of exercising image rights. So with that, we go into a discussion of looking at social media and the role it has played in terms of emerging trends with image rights. So in exploring how image rights has impacted the use of social media, how then is it now being applied in terms of marketing, advertising, and especially now that we have influencers who also introduced a new spin into how marketing and advertising is done by companies and businesses?
You know, there's a very interesting podcast episode I once had with I think she's the CEO or the chairperson, I'm not quite sure now, but of the Advertising Regulatory Board of South Africa. And the influencers were at the center of that conversation. I then had another podcast episode with Subhash Patoria about the same topic in the context of India, given their entertainment industry and its unique elements. And one of the things that we are seeing is that we have a couple of trends that are lasting quite well on social media, which is the creation of memes, creation and distribution of deepfakes. The influencer market is growing bigger. And then we also see, especially on the end-to-end encrypted kind of social media like WhatsApp, we see the increasing creation and use of GIFs and stickers. And what this presents us with is what Trosner once termed as a privacy trade-off, where people are willing to share their images, their voices, their likeness with the world in order to get some sort of commercial gain from it. The problem, though, is sometimes the one who maybe creates a meme or a deep fake may not necessarily be the person who has the rights to that personality that's been used in the meme or the deep fake. And then we also see the influencer market, and we look at how does one become an influencer. Think about it. Initially, they don't start by going to a company to say, can I talk about your brand? They simply show up on maybe a YouTube channel or Instagram stories, and they start commenting about products and services, which means that we're living in a world where it seems like information, including people's identities, and business identities and products are free to use on media that people share on social media. So then influencers develop out of this. And what often happens is you see that the way in which people gain commercially on social media has evolved, because in the past it was usually focused on the monetary gain kind of manifestation of commercial gain. But there is a book that I'm currently working on where I'm demonstrating that if you look at the way people get likes, follows, shares, thank you payments, gifts, verified profiles on social media, it has changed the way in which we market. It has changed the way in which we gain commercially from using people's identities. And so the presentation of these trends, the memes, deepfakes, influencers, etc., raises new questions about whether it is sustainable to still protect people's identities through the right to privacy, or should we move over to focus more on the image rights protection and harness that kind of protection and bring international harmonization as to how image rights are protected? Because also the differences in the different jurisdictions about how these are regulated is a contributing factor to why people may not realize the full protection of their image rights. And so with influencers, I particularly find it interesting, and this is a question I raised even in my doctoral studies, that if we are differentiating how we treat ordinary persons from how we treat celebrities, we will have a problem where persons who are deemed influencers become sort of like a missing middle. They don't either fall into the ordinary category and they don't fall into the celebrity category, right? And the problem is that someone's right to privacy, especially in South Africa, your right to privacy may be limited by how much of a public figure you are and what activities you are engaging in. Because obviously people can comment for truth, freedom of expression related issues. People can create just cartoons and stuff like that when you are a public figure. And they could actually get away with it on the basis of the protection of freedom of expression. Whereas the rule may be a bit stricter when you're dealing with private persons whose privacy may be slightly more protected than a celebrity. But if you flip it around into the image rights context, then it's the ordinary persons who may not be able to prove that the commercial interest that they have in their identity, depending on the situation. But this is exactly why I appreciate the South African approach more than the others that I've actually observed. Because in South Africa, we don't really need you to show that you are famous in order to claim for image rights. Anyone can do that. Whereas in the States, it becomes a bit more tricky because the celebrities get more justice, I would say, using their publicity rights than the ordinary persons. And also in the English courts, as you've seen, with the passing off claim versus the privacy claim. The influencers become influencers overnight almost, some of them. So the question of whether they are public or private person, it's a tricky one that cannot really be determined carefully. Because would you call an influencer an artist? Maybe, maybe not. Would you call them an ambassador? Maybe, maybe not. Depending on the agreement between them and whatever service or product that they're discussing or influencing, right? And so it seems that we may need to revisit some of the ways in which we protect image rights, given the rise of influencers. However, the best thing that I would recommend for influencers is to always have a lawyer who's going to check through whatever agreements they get into to make sure they don't sign over the use of their identities too extensively.
Thank you so much for that. With what you have just discussed, I'm seeing certain similarities between also how South Africa and Kenyans look at image rights, especially when it comes to adjudicating the same in court systems. We're seeing a similarity in terms of the fact that anybody can be able to actually go over and claim image rights. It doesn't have to be a celebrity, and they'll be given the same weight, which is also very distinctively different from how image rights or publicity rights are handled in the UK or the US. Similarly, we've also noticed that within the Kenyan courts, cases on image rights started being raised in as early as around 2016. And if you really do a deep dive, you might find some from 2012, some cases filed in 2012. But the angle to which you were always claiming publicity rights or image rights was always from like a constitutional perspective, was always infringement of the right to privacy, freedom of expression, sometimes human dignity. So that's the angle within which they were always claiming image rights. Now, with the Data Protection Act coming into force in Kenya in 2019, we are seeing an increase in those cases where most people are now going for image rights and looking at it in terms of the data protection angle of it. This has been noted, especially with the complaints that are being filed with the Office of the Data Protection Commissioner in terms of providing remedies for specific violations of image rights, which has also sort of led to the same to countries and businesses, to certain businesses within the Kenyan context being filed for suits against. And also we are noticing a trend whereby we are having them have to pay certain fines or certain amounts for violating image rights. And it's not necessarily of celebrities, it's just of normal citizens, Kenyan citizens. And with that, we're also noticing an influx now in some of these either restaurants, bars, or public places that normally take images coming up with waivers and posting up waivers of if you access this building, please know that your images are likely to be taken, which there's an ongoing argument right now on whether that notice, that waiver suffices as accurate notice or giving away of certain image rights. So I'm noticing those sort of similarities. And with that, I also wanted to ask, with that sort of trend coming up, what other cases are we seeing sort of come up out there that give illustrative consequences of violating image rights? Because from the Kenyan end, we are seeing that most of the consequences that come out of it tend to be monetary, so that there's a specific amount of fine or monetary gain that's given to those whose image rights have been violated, and there still isn't hard on stone that this is the direction you're going to with respect to claiming image rights. It's either the Constitutional Court or the Office of the Data Protection Commissioner. That isn't really clear for us yet. And in some instances, we're even finding the Kenya Copyright Board instituting certain guidelines or notes with respect to image rights. So for us right now, it's very all over the place. It's either constitutional, it's either data protection, it's either IP. And for the intellectual property one, it's especially for things like memes, which you've also mentioned, because we had a case whereby that instigated rather the Kenya Copyright Board to come up with a guideline, a meme guideline, or like a guidance note with respect to a meme that came out. But the person who ended up using it, there's a company that ended up taking it for an online advertisement of theirs, and the people who actually appeared on the meme ended up sort of suing them for that. So it prompted the Kenya Copyright Board to sort of make a guidance note on the same. So just with that brief highlight and context, what would you say are other illustrative cases and consequences of violating image rights?
So, illustrative cases, I could list so many, but I wanted to quickly dial back to this meme issue, that even though memes were not popular or commonly known back in the years 2010, I do remember a judgment, Leroux versus Day, in the Constitutional Court, where the high school pupils had taken the images of the principal and deputy principal, who were both male, and they had superimposed their faces on another image which contained gay bodybuilders, it was said. And they printed that picture, put it on the notice board. It went, I think it also took the rounds on Mixit. I remember Mixit was still a thing. It was the old WhatsApp, basically. And the deputy principal in particular took it all the way to the Constitutional Court. But he didn't even use the right to identity. He went for rather privacy and human dignity claim. And I always say that this was, in actual fact, the first meme case, because if you think about memes, it is that you combine images of someone, you make a joke of it, and you publish it for people to see. It's just that it happened offline, where they put the picture on the notice board at the school for everyone to see and laugh at. And there were some serious consequences there, claims, orders and claims for that particular behavior. We see also consequences in the Grutter versus Lombard judgment, Supreme Court of Appeal, where you had two people who were using the same premises to run their law firms, and they had just put their names next to one another on the building for just uniformity, not that they were in a partnership or anything like that. But when one left, the other continued to use the name of the other guy. And so that's when Grutter came and said, but listen, I have a problem with the fact that you are using my name for this purpose, and I have legitimate interests in my identity. This is creating a false impression to the public that I still have my business located here. Please remove it. And that is when for the first time, the Supreme Court of Appeal recognized the right to identity, basically image rights, as an independent right that needs to be protected. And the order there was obviously for the name to be removed. We also see common law remedies here, like a claim using the actio injuriarum, which is basically a claim for compensation. We've seen it in the Wells judgment in operation. And in Wells, it was about the 12-year-old girl that I mentioned earlier on, but she was awarded a sum of 10,000 rands, not much, and obviously cost in her favor, which obviously will relieve the burden of having to litigate against a magazine company. But inherently, our common law remedies are restrictive in terms of how much compensation you can get. We don't get claims in the millions for the actio injuriarum. In fact, it's been criticized by our courts as well. But then we have this landscape that because South Africa is a hybrid legal system, even though we have common law rules, we have legislation that impacts these rules. And one or two of these acts include the Protection of Personal Information Act, which is basically our data protection legislation, as well as the Cyber Crimes Act. You can also include Electronic and Communications Transactions Act in there as well. But I mentioned the POPI Act and the Cyber Crimes Act in particular because of the dynamic that they present, is that anyone who has an image rights violation is basically capable of bringing in a complaint through the Information Regulator of South Africa, provided that they are dealing with a private or public body as defined in the Act. And they could pursue an image rights claim in that angle, especially if it's a matter of just trying to get someone to remove an image or something like that. The Cyber Crimes Act also deals with malicious communications. It basically regulates the misuse or the unauthorized use of people's images, especially those that reveal their private parts and so forth. And what it does is to criminalize that kind of conduct. But it is not clear as to when is this, to whom does it apply? So who's the victim in terms of the Section 16 of the Cyber Crimes Act? Is it if my face is used and superimposed on the image of is it really concerned about the victim as whose private parts appear, or me, who my face appears there even though the rest of my body doesn't appear? But a literal reading of that provision tells me that it's more concerned about the one whose private parts are being published rather than the one whose face is there, which means persons who feel that, well, I may not be the one violated in terms of the nudity part of the picture. They may have to still fall back on common law remedies. They may have to go for criminal injuria claims, even or prosecution via criminal injuria under the common law crime instead of the Cyber Crimes Act. So much like with your jurisdiction, in our jurisdiction, the playing field is quite complex. There are different channels and avenues that people can use to protect their image rights. Because we've also seen how in one case, H versus W, where there was a contention about the removal of a post on social media. And the defendant said, but the plaintiff should have first exhausted the remedies to get a takedown notice, to have this removed first. And the court held that no, you can always institute an interdict directly to the court, where you can basically get relief without having to show that you've already tried to remedy the situation internally with whatever social media platform you're dealing with. So the dynamics differ. It's also very factual in most cases, because our most recent case, which I've noted has a huge impact on this image rights and privacy landscape, is the one that went to the Supreme Court of Appeal, where someone's images were used to complain about them for animal cruelty. And the images that were used were the images that he himself had posted on his social media page. And the Supreme Court of Appeal basically held that the one who posts their pictures online cannot then turn around and have an expectation or a legitimate expectation of privacy in such an instance, because they themselves have published their images. There's no sign of positive steps taken to prevent people from using their images. I do have the opinion that if that case was heard as an image rights case instead of a privacy case, it would have succeeded for the plaintiff and not for the defendant. So yeah, we do see a range of things. It always depends on, you choose the remedy based on what outcome you want. Do you want money or compensation? Is there a loss that has been suffered? Or do you just want to interdict someone and to tell them to cease the conduct, so remove the post? Or if you know it hasn't been posted, you want to prevent them from posting. But there are a range of remedies.
I completely agree with also understanding the sort of remedy you want to see, because right now I don't think people are necessarily aware of even the remedies that exist. They just know I can go to court with this and this is what I can do, especially from the Kenyan context. Some people may be aware just because of the legal advice that they do receive before instituting comments or complaints, but I don't know that many people are actually aware of the remedies that they can get. So contextualizing that has been amazing. And just going back to some of the points that you've mentioned in your discussion about the fact that image rights can be, you can attain image rights from different avenues. From what you've mentioned, it could either be constitutional, it could be with respect to the cyber crimes, and it could also be with respect to the data protection. In our case, the Data Protection Act, and in some instances, you could apply certain common law remedies. So, given the extensive, I would say, array of options we have to exercising these remedies, which also go to sort of knowing what you want to claim. Do you want it taken down? Are you trying to look for monetary compensation? With respect to looking at image rights and how it attains to the right to identity, because I've also noted the fact that image rights goes beyond just your picture. You know, you've mentioned a case where it was someone's name appeared, the law firm case, it was someone's name and that name had to be taken down. People right now are just looking at image rights in terms of it being an image of me, in terms of it being a picture of myself and a picture of myself being represented in certain ways. And the fact that now noticing that image rights goes beyond just, let's say, your picture. It could be your voice, it could be your voice, it could be your name, it could be how it's been represented, and how it shows up in certain platforms or in certain ways. What practical advice could be given to individuals to be able to first identify to be able to identify in what ways their image rights maybe have been violated, and in identifying how their image rights have sort of been violated, how then are they able to pick remedies that would be applicable for them for sort of enabling them to exercise their image rights, but also not file them in the wrong place, so to speak. I don't know if you get what I'm saying, but for them to be able to sort of say, okay, so these are my image rights, and my image rights include, it could be my image, it could be my face, just my face, it could be my voice even, it could be just my name being out there in a specific way. And this is the avenue that I can take to sort of get remedies, and this is the remedy I'm seeking. What advice would you be able to give them, just based on either as individuals or in terms of business associations that they have?
So I think the first thing that one needs to ask themselves is, who is the perpetrator? What is the capacity of the perpetrator? Because if the perpetrator is just an individual natural person, then your dispute really lies at the common law level, if it's individual versus individual. Because if you look at the Protection of Personal Information Act, its scope is limited to private and public bodies that process personal information. And so the only time that you would bring in a complaint to the information regulator under POPIA is when you are dealing with either one of those bodies. So sometimes it may be an individual who's acting for such a body, a private or public body, and that would fall within the scope of the POPIA Act. So that's the first question. Who is the perpetrator? The second question is, what kind of conduct are you trying to remedy? Because depending on the conduct, it may strictly be a civil case. So basically you bring in a delictual claim, which is basically our version of tort law. Or it may be a criminal case. These are classified as offenses under the Cyber Crimes Act. Because obviously when you start moving into the criminal sphere, it is not really you who's pursuing a claim. You're not going to get compensation from that kind of an avenue. Instead, you are reporting the matter to the South African Police Service. They investigate. If they find sufficient evidence, they'll prosecute, take the person on trial. So one needs to ask, what is the nature of this conduct? Which rights does it violate? And who are the parties? In what capacity are the parties appearing? And then you can start picking and choosing which one you want to go for.
Thank you for that. So basically the line is, who is identifying the perpetrator, what kind of conduct are you trying to remedy, and which rights have been violated in terms of looking at your image rights. And also with that, I think one thing I have definitely learned from this discussion is the fact that image rights generally goes beyond just the general protection. We usually look at it in terms of either your right to privacy. It goes beyond that. The right to privacy is the first interlink of it all. Then it can expand and go beyond just your image being used either for commercial purposes without your consent, or your image being out there in a way or being portrayed in a certain way that you would not necessarily have liked for it to be portrayed, which specifically goes into looking at the right to human dignity and such like that. So the image rights is quite wide. It's quite vast and wide, and just it's been interesting to see the different elements and areas in which image rights is now expanding into, because with the Kenyan situation, in as much as we now have the Data Protection Act, we're noticing that most of it is very much concentrated within it, either being looked at within the context of data protection, your data protection, or within the context of your constitutional rights, which emanate from the right to privacy, then we go to the right to human dignity. But it's been quite interesting to see the extent to which it's expanding just beyond what we've just normally seen it on the surface of it. So as we conclude this amazing discussion on image rights, do you have any key takeaways with respect to image rights, either with respect to emerging trends or with respect to how it's evolving generally?
I have a lot of takeaways, but I'm going to start with something I wanted to mention earlier when you started by talking about how vast this concept of image rights is. One of the things that I open up the book that I'm working on with is to problematize the very terminology that we're using: image rights, right to identity, publicity rights. Because, as you said earlier, people tend to believe it's just about your image in the form of a photo, video, something like that. But the term image is used broadly when you look at what it means, what the protected interests encompass. And key takeaways for people who are concerned about their image rights is you need to think about your social media presence a little bit more carefully and intentionally. And you need to ask yourself, do I need to post 100 pictures of myself a year? Or is it sufficient that I post only a few, a limit? Because also, when you think about the deepfakes trend, the more your images are out there, the more the AI trains using this information, and the more they'll be able to perfect how you look over time. So you need to ask yourself, do I always need to post a selfie? And do I always need to be facing forward to post a selfie? These are now practical issues around how people interact on social media. But for businesses, if you know that you run a business that will require you to take pictures of your employees for purposes of marketing or something like that, which is basically commercial use of identity, you need to make sure that your employment contract covers this issue very well. Of course, as a business, you cannot own someone's identity or personality interest. A person can never part with these interests, but you could regulate to what extent are you allowed as a business to use these people's images. Every engagement you have with maybe guests and so forth for podcasts, even on my podcast, I'll use a guest release form to allow me to have the rights to use that person's image for purposes of the podcast episode. And by image, I'm speaking broadly: their voice, their likeness, that unique thing about them, their picture for the poster. So all of that is well thought out about how do I always make sure that we are in agreement that I am going to use your image for either public or commercial purposes. And whenever you're dealing with children, say you are running a school with tots, you must have it in your policies how you deal with their images when you have events. And their parents need to sign informed consent forms about allowing you to use their identities whenever there's an event or something like that. But one of the things I want to just close with is, I mentioned the privacy trade-off earlier, and we are living in that era. People are willing to trade off their privacy to get the likes, the follows, all these new forms of commercial gain. I do not see how the common law protection of the right to privacy can continue to protect us in this era. It may have limited application in future. And so it is now the time for image rights protection to shine, to show its strengths, that even with the privacy trade-off, it can still protect people's identity interests. It can still protect them against commercial exploitation and falsification. It can still really provide the remedies, the same remedies that privacy would, but just on a different basis. Because there are many cases that I've seen that are pursued as privacy cases instead of image rights cases. And sometimes when you look at the questions involved and the issues involved, you realize if this was pursued as an image rights case, it would have succeeded. We need to change our minds about privacy a little bit and accept that privacy now has become a data privacy or data protection issue where we can't really prevent the use of our personal information. We can only regulate the lawful processing thereof, and thus all the other matters of non-consensual use for commercial gain and public use, they can fall within the image rights scope. And we can really come together as jurisdictions to harmonize how we deal with image rights so that we can strengthen that system of protection. Thank you.
Thank you so much, Dr. Nomalanga, for all your insights on image rights. Definitely, I myself have also learned quite a bit throughout these discussions, and definitely cannot wait to read the book that you're working on. Can't wait for that to come out on image rights. As we conclude, by the way, this morning there was a LinkedIn image post that was posted by the supermarket Carrefour. They had an opening of a new branch, and they happened to take pictures of the people who attended the branch. But the funny thing, or the distinctive thing about the picture that they posted on LinkedIn, is that it had emojis on everybody's faces if you were facing the camera. So if you're facing the camera, your face was covered by an emoji. Even if there was a portrait hanging on the wall somewhere, I think they covered the portrait of the president with an emoji. So they covered everyone's emoji, and the caption was reading, thank you for everyone for attending this. Can you spot anybody's face on this? No, you can't. So it was quite funny just to see that, and to see that those are the lens that now people are going to make sure that they're not sued inadvertently for breaching anybody's image rights.
Do we really have to go to those extremes? Because remember that in countries where you have laws that allow public photography, photographs taken at public events may not violate image rights. They can be well covered by the right to freedom of expression of the media and of the particular entity that has hosted the event. And I think the culture should rather evolve to say to people, whenever you organize an event, whoever registers for the event must sign that I do consent to my photographs being taken in the crowd format. So nothing zooming specifically on me, but if it's in a crowd context, I don't mind because I'm attending a public event. That, especially in the common law jurisdictions, can cover a person on the basis of the right to freedom of expression.
Yeah, I think that's something that needs to be taken into consideration, and especially considered amongst even just universities, institutions of learning, and other businesses and institutions. So yeah, with that, I think we come to the end of this episode. Thank you so much once again, Dr. Nomalanga, for being part of this podcast episode. All the resources that you might need for this podcast, or that you've had in this podcast, will be posted in the show notes. You'll also find a link for Dr. Nomalanga's podcast, Image Rights by M. Mashirini. It is very insightful. You'll get so much information about image rights from different jurisdictions. And with that, we'll see you on the next episode of the Friendly Troll podcast.